Kevin Thomas Ferenczak, MD Chicago, FaceTime video.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle, your host for this hour and also the next hour here on the broadcast stations of Civic Media. Delighted and honored that you have chosen to spend some of your weekend time in conversation and discussion with me and my terrific producer, Max. I am coming to you this weekend from the main studios of Civic Media in beautiful downtown Madison, just within the shadow of our Capitol Dome. Max, my terrific producer, is in Radio Park in Racine, and together, once again, we are inviting your questions, your comments, your inquiries, your perspectives on the subject matters that animate our discussion this weekend. That phone number is 855-752-4842. You can call, you can drop a note in the Dropbox, and be a part of our discussion this weekend, focusing upon the United States Supreme Court, as we often do. This broadcast, this edition of Amicus, focusing especially upon the recent work, the recent activities, and yes, some of the recent conduct of our United States Supreme Court justices, including the Chief Justice, John Roberts, and yes, focusing a lot this broadcast upon another one of the associate justices, and her name is Amy Coney Barrett. I'm going to talk about the ways in which we have seen her views, her perspectives, and yes, even her writings from the Supreme Court evolve fairly recently from moving to the closer to the center, from the far right, which was where arguably Donald Trump placed her, the consequences of that, which we will also discuss on our broadcast this weekend, as she decides cases based more and more upon the interests of the American population, also getting not just pushback, but threats and a sense from some elements of our population, inappropriate and completely contrary to the law, suggesting that she has been a bad Supreme Court justice. We'll get to that as well. We're going to begin our discussion, however, with an invocation of what the Supreme Court is supposed to be all about. Yes, indeed, from time to time, we go back to some original documents, including the Federalist Papers, again, written by three folks named Hamilton, Madison, and Jay. Jay goes on to be the Chief Justice of our Supreme Court, and eventually tells us that it's decidedly the province, the purview of the judiciary to just tell us what the law is. In fact, he's got some support for that from the other authors of the Federalist Papers. Here's what Hamilton and Madison write about this notion that there are shared powers among the branches of government, and that indeed it is the responsibility of the judiciary to decide what the law is. This is what they write. This is Federalist Paper number 78. Some perplexity respecting the rights of the courts to pronounce legislative acts void. That's basically to review and determine whether or not things that the Congress has done are right or wrong, because contrary to the Constitution, has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. That's a long and somewhat convoluted way of saying some folks out there, as they're looking at the Constitution before it's passed, obviously, all of these letters, advocates principally to the population of New York, but other places up and down the East Coast at the time, all of this advocating for the adoption of the Constitution, arguing that indeed those people who say that somehow the judiciary should not be able to take a look at and determine what is legal, what is not, what is constitutional, and what is not, they're wrong about that. Hamilton goes on to say, it is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance in all of the American constitutions, a brief discussion of the grounds on which it rests cannot be unacceptable. Kind of a double negative there, basically saying we've got to talk about this, and goes on once again to commission the United States Supreme Court and such other courts as the Congress may establish to do exactly that. It says this: there is no position which depends on clearer principles than that every act of a delegated authority, that includes the executive branch, does it not, contrary to the tenor of the commission under which it is exercised, is void. Let me read that again. There's no position which depends on clearer principles than that every act of a delegated authority, again, 3 branches of government in our federal system, many state systems as well, other things locally and county systems as well, contrary to the tenor of the commission under which it is exercised, is void. Here we go. No legislative act, therefore, contrary to the Constitution can be valid. To deny this, the authors of the Federalist Papers tell us, to deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. Good words, thoughtful words. Again, way back at the time that our Constitution was under consideration, eventually, of course, passed in 1787, 1788, 1789, ultimately a requisite number of states pass our Constitution, and we look forward to celebrating another anniversary of that coming up later this year. Based upon that, and based upon our commission in this edition of Amicus, a Law Review, we're going to be focusing almost exclusively on the United States Supreme Court, including a major decision of just this past week in which the Supreme Court rejects Donald Trump's attempts to freeze foreign aid. And yes, invoking implicitly, not explicitly, the rules and the principles set forth there in the Federalist Papers. You've got a modest majority, a slight majority, a 5-4 majority, also very interesting, who makes up the majority. We'll talk about that, telling Donald Trump, you can't do this, that your conduct has got to be consistent with the law of the Constitution, with what the Congress has established. You cannot do this. You can't freeze this foreign aid without legislative action. That's what the Supreme Court, frankly, preliminarily said. This is not a final decision, basically reviewing of what the lower court is doing, sending it back to the lower court for a little bit more definition about what the judge wants from the parties, including the administration. But it is undeniably a major blow to the Trump administration and its efforts to change government, and in this particular case, change the way in which we support our allies and others around the globe. We've talked about this a lot. This is the USAID stuff. This is the notion that by virtue of decisions by our Congress to send monies overseas, we are stronger here at home. And we're also, most importantly, helping people overseas in countries not ours. That is a very good thing. The United States Supreme Court, again, subtly, preliminarily, not finally this past week, saying, Mr. President, you can't do that, or at least there needs to be more proceedings about all this, sending it back and not giving Donald Trump the emergency freeze that he wanted on the lower court decision to freeze him. Again, lots and lots of language going on there. Along the way, this particular decision, which we're going to analyze, has everything. It's got procedure inside it. It's got foreign policy. It's got intellectual dishonesty when it comes to at least one of the dissenting justices. His name, of course, well known to all of you. We'll get to in just a few moments. We'll leave that as something of a mystery as we go forward here. And also another justice whose name I've already mentioned. And she finding herself in majority, just a modest majority, as she also develops more and more of her own position in the Supreme Court, aligning herself more and more with the so-called, again, liberals of the Supreme Court, an appellation, a characterization that I don't necessarily embrace, just because there are many circumstances where those titles, those characterizations do not apply. But this case, a major important case coming out of the Supreme Court, again, not resolving the case ultimately, but determining that Donald Trump is not successful in overturning and stopping the lower court from stopping him. And we'll talk more about that. A couple of other things that the Supreme Court has done recently, one of them just this past week, a major EPA, Environmental Protection Agency decision having to do with the Clean Water Act. We've talked about these things before. Once again, the Supreme Court back and focusing on environmental issues, talking in particular about a case coming out of San Francisco in wastewater management, our clean water, dealing a blow to the EPA and its authority to implement and follow up on the Clean Water Act. We'll talk about that. A 5-4 decision, once again, narrow majority there. but a different majority, a different minority there. We'll talk about why that's important too. And finally, we'll talk about a case of a couple of weeks ago that did not get a lot of attention, but this one is unanimous, once again indicating that we've got times when all members of the Supreme Court agree on certain things. Here's a situation where the Supreme Court has said that some Holocaust survivors do not have a cause of action against Hungary for past damage, past harms in the wake of World War II and lost properties. We'll talk more about that. That's a 9-0 decision. Then beyond that, some oral arguments of just this past week. Also important for us to understand, anticipating that the Supreme Court's going to be issuing decisions again on probably about, well, it's already issued 2 or 3 decisions, but about 60 remaining cases coming up in May and June, maybe even in July. 2 of those we're going to focus on, in particular Mexico in our courts. And the question is whether or not Mexico can properly sue the manufacturers and some related defendants for the violence that Mexico is seeing in its nation, arguably, allegedly based upon the manufacture of guns here in our nation, brought across the border, causing that great harm, that violence in Mexico. The question is whether or not they can go ahead with that lawsuit, argued in front of the Supreme Court by both Mexico and representatives of the gun manufacturers here. Sort of unclear, a skeptical court about the process going forward there with the Mexico civil lawsuit. We'll talk about that. And then another oral argument also of this past week having to do with nuclear waste. And again, the authority of another agency. This one's the National Regulatory Commission, having to do with nuclear waste and where, in fact, it can go after waste comes out of the nuclear process and the location of that waste in America. Finally, a couple of other opinions that have to do with the authority of the president. Once again, coming out of the Supreme Court and going to district courts, one of them coming out of the Washington, D.C., determining that the NLRB is what it is. The president can't do what he wanted to do there. And also a case involving domestic spending, that case coming out of a judge in Rhode Island. All of that coming up here on Amicus, a law review, all of that based upon our work and our focus on the United States Supreme Court. Stay with us for all of that important discussion. And my producer Max, as we talk in an all Supreme Court Amicus Law Review this weekend. Lots of things going on there in the so-called third branch of government, only because it is the third article of the Constitution. Again, thinking about the powers that it has these days, both implicit and explicit, and the ways in which the Supreme Court justices behave. And that is the predicate, that's the beginning of how we get into all of this on this edition of our broadcast. Many of you, I suspect, watched and maybe even heard separately the words of our president at the State of the Union this past week. Something happened as the State of the Union was finishing up, and it has to do with two Supreme Court justices. Not all of them are there. It used to be that all of them showed up. Now we have routinely a number of absences, but at least two of the justices were there. There were others as well, including Elena Kagan, and among the group there, of course, was the Chief Justice. His name is John Roberts, and Amy Coney Barrett was also there. Some things caught on a hot mic and some things caught on camera as the President of the United States came off of the podium, walked down to the Supreme Court. They are seated there, the members who were there, right in front of them there in the well of the House of Representatives. And what happens next has gotten an awful lot of attention, and it underscores in its physicality, and apparently what the president said to the Chief Justice underscores the problem that we have in America today, and that is this notion that somehow the branches are not separate, and that indeed, at least in the president's view, perhaps the Supreme Court is his Supreme Court, doing what he wants. What happened is, of course, that the president came down and put his hand on the right shoulder of the Chief Justice. Nothing wrong with that. Nothing wrong with greeting the justices. But a hot mic picked up what the president said to John Roberts. He said this. He said, "Thank you again. Thank you again. Won't forget it." Again, as he placed his hand on Roberts' shoulder and his arm there. And of course, that has led to an awful lot of well-based speculation that what our president was doing was giving the Chief Justice thanks, appreciation. Thank you very much to the Chief Justice for penning that major catastrophic decision back in July of last year, the conservative majority establishing for the first time in our nation's history, as we have talked about a lot on this broadcast, that a president does indeed enjoy certain immunities from criminal prosecution, can indeed be above the law, and most significantly, I have argued, establishing a very, very powerful United States presidency, an executive branch that needs to be active, needs to be nimble, needs to be aggressive, and cannot be encumbered by other things, for example, like criminal prosecutions, and needs to act powerfully. Donald Trump plainly doing that in recent days and weeks, apparently thanking the Chief Justice for what the Chief Justice did. Didn't give us a lot more description there, but plainly indicating that he appreciated that, as the president appreciated basically the Chief Justice writing that opinion that got him off the hook, that set in motion a whole series of events. Again, the cases never went to trial, at least not federally. And as a result of that, Donald Trump now he is convicted of state offenses in New York, but he is a president of the United States of America who had faced at least two federal cases of major dimension, both of those effectively going away, including this notion that somehow a president is immune from the very prosecutions the Department of Justice brings. The president thanking the Chief Justice this past week for doing just that, erasing once again the separation of powers, and suggesting very strongly that the president believes that the United States Supreme Court is his court. And when it does what he wants it to do, he is happy, and he will let the Supreme Court and the Chief Justice know about that. Now, the other important thing that happened was all visual, and that is that Amy Coney Barrett, sitting there, of course, during the course of the entire speech, looking somewhat uncomfortable about many of the things that our president said, but also at the very end, as this was going on between the president and the Chief Justice, also looking over, difficult to read, not a psychologist, not a student of human behavior, but it certainly appeared to many of us, I suspect including you, that Amy Coney Barrett found that relationship, that contact, that communication between the president and the Chief Justice unseemly, and came close to frowning over it. Didn't really raise her eyebrows, but look back at the camera angle on that, look back at what was recorded. Amy Coney Barrett almost certainly expressing some dismay that this had happened. Amy Coney Barrett, Associate Justice of the Supreme Court, also looming large in what the Supreme Court has done just this past week, as we continue more to talk about the United States Supreme Court and what it has done. Significantly, right after that happened, the morning after of Wednesday of this past week, the Supreme Court, in a 5-4 decision, yes, indeed, Chief Justice John Roberts, Associate Justice Amy Coney Barrett joined the other three so-called liberals on the bench, Again, doing what all of us would anticipate an independent Supreme Court would do. That is basically upholding the law and saying to the president that this is what the law is, and when you violate it, you need to be responsible to the courts for explaining that. Supreme Court on Wednesday, again, right after the State of the Union, 5-4 decision of the United States Supreme Court, a close decision, rejecting, saying, no, President Trump, we will not, in fact, grant your emergency request. He came to the Supreme Court asking on an emergency basis to freeze nearly $2 billion in foreign aid in a closely divided decision, once again, 5-4. We know how this comes about, and we know well because we've talked about this in the past. Judge Amir Ali, a federal district court judge, Washington, D.C., had issued a temporary restraining order. Again, this is the preliminary part of the case. A number of petitioners come in and say, we don't like the fact that the president is shutting down USAID, although effectively, for practical purposes, if you're there in Washington, you'll see that that office is basically gone. We also don't like the fact that through USAID, the president has frozen about $2 billion with a B dollars intended by the Congress through the USAID and other mechanisms to support friends and allies overseas who need that money. For what? For food, for health care, for democracy, for government stability, for all kinds of things, for commerce, for medical attention, addressing the spread of diseases, all kinds of things. President saying, no, we're not going to do that anymore. People coming into court saying that the president does not have the authority to override the decision of the Congress. Stop that from happening. And Judge Ali says, yeah, I think that's probably right. I'm going to enjoin you. I'm going to stop you, Mr. President, initially from doing just that. You have no explanation for this blanket suspension of aid the Congress has directed be paid. That's what the judges said. And in the wake of that, it appeared that the administration officials said, that's very nice, Judge Amir. We don't care. It seemed as if the administration was evading, simply saying we're not going to follow that, maybe defying the order, as Judge Amir seemed to indicate as well, saying that they're still entitled to continue to conduct a case-by-case review of some of these monies, and we can make that decision even though you've told us not to. So what happens is that the plaintiffs in this case come back to Judge Amir and say, you know what? They're not cooperating. They're not doing what you told them to do, Judge. And the judge then comes back. He once again orders the officials to go ahead and make those payments of $1.5 billion, sets a deadline for midnight the next day. And it's right after that that the president, the administration, your Department of Justice runs into the United States Supreme Court and says, stop Judge Amir from causing all this trouble. Stop Judge Amir from stopping us from stopping the funding. Lots and lots of language there, lots of stopping going on here. But the reality is that as a result of what the Supreme Court did this past week, Supreme Court chose not to do what the administration wanted. We'll talk more about that as Amicus, a law review, continues. is Amicus, a law review here in the broadcast stations of Civic Media. My name is Jim Santelle, joined this weekend, as always, by my producer, Max, and together we're taking your phone calls, your questions, your comments. That number, 855-752-4842, talking all about the United States Supreme Court, an almost exclusive focus this weekend on our High Court. Not only talking about the behaviors, the conduct of some of our justices, but also what they did just this past week. This 5-4 decision handing Donald Trump, the President of the United States of America, a blow to his plans to stop foreign aid from going forward. Not the final ruling on this. This is also temporary, sending the whole thing back and saying, well, we're not going to stop the plans of the administration, freezing, that is. You've got sort of, once again, a double negative there. We're not going to upset that right now. What we are going to do is we're going to send this back to a district court judge who plainly is hostile, appropriately hostile to what the president is doing. We're going to send it back, and we're going to tell that judge that he should clarify what obligations the government must fulfill. Well, the judge, again, Judge Ali, has been fairly clear about that. Nonetheless, that's the posture of the case, sending it back to the lower court judge, telling the judge that, yes, indeed, we're not going to overturn your freezing of the decision of the president to freeze those foreign aid monies. Lots of things going on there. We're going to let you go ahead and hear the attacks of the plaintiffs upon what the president has done that basically prohibits these monies from going to help people overseas. Along the way, as I indicated at the top, some very interesting things going on inside this case. We certainly have a Supreme Court procedure. This is one of those quick orders, sometimes called the shadow docket, emergency application. As a result, the court's brief order is unsigned. And that's typical when the justices act on emergency applications, again, saying only the trial judge should go back and kind of clarify what obligations you're talking about here. And as a result of that, that is the ruling. That's the law of the Supreme Court coming out of this particular case. Also has some other aspects of it. Again, it's got the emergence of Amy Coney Barrett, as we have seen, and we'll see again later in this very broadcast, as a voice here, along with the Chief Justice, joining the other three, the so-called liberals on the bench, to hand Donald Trump this result that plainly he is not happy with, even though it is not a final decision at all. Amy Coney Barrett, we continue to look to her, at her. We'll watch her further as she develops her own level of jurisprudence and, yes, indeed, some independence on the court in many, many ways. This case also has intellectual dishonesty. I teased before a Supreme Court justice among those four who engaged in what can only be called intellectual dishonesty in writing a scathing dissent, a slashing 8-page dissent. Sam Alito is his name. You're not surprised by that reveal at all, are you? He joins other members of the court in saying, no, we should go in the opposite direction. What the majority here has said about this case, he said it's gone profoundly astray. He said this, does a single district court judge who likely lacks jurisdiction, I don't know where that comes from, but have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer, Alito said, to that question should be an emphatic no. But a majority of the court apparently thinks otherwise. I am stunned. Well, Mr. Associate Justice, you can be as stunned as you like. The fact of the matter is that there is an answer to your question. And yes, that's our system as established by the Federalist Papers, by the Supreme Court, by other courts. And that is that, yes, indeed, federal district court judges do have responsibility to decide what the law is. You can appeal those decisions to appeals court, ultimately to the Supreme Court. But yes, indeed, a judge, in this case, again, Judge Ali in the district court in the District of Columbia, does have the power to compel the government to pay out the $2 billion tax amount that has been suspended unconstitutionally, illegally by this president, contrary to what the Congress has said. Note that Alito also says probably lose forever. It's not a matter of losing the money, Mr. Alito. It's a matter of spending money that the Congress has authorized in its appropriation process and ensuring the money gets to where the Congress, our representatives in Washington, have intended it to go. The answer to the question, he says, is emphatic no. Just the opposite is true. He goes on. There's even more intellectual dishonesty. He wrote again that apparently the government now has to pay this $2 billion post haste. Well, the budget allocation from, again, previous budgets, this is nothing new. This has been out there for a long period of time. It's the president who decided not to go ahead and implement what the Congress wanted. There's nothing post haste about it. It says not because the law requires it. This is the Associate Justice Sam Alito writing, but simply because the district judge so ordered. He's plainly focused upon this jurisdictional issue. Sorry, Mr. Associate Justice, the district court judge does have the power to do it. You can review that as you are doing right now, but a district court judge does have that power. And then he goes on to say this. As the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. And that's exactly what you're doing. You're reviewing all of these lower court things. He says today the court fails to carry out its responsibility. No, you did just the opposite. Again, we do embrace the rule of law in America, and that requires our understanding that the Supreme Court will tell us what the law is. It is significant as well that the Associate Justice, again, writing on behalf of the dissenting group there, says the administration should not be thwarted once again by a single judge. He is very much fixated on that. He says today the court makes a most unfortunate misstep that rewards an act of judicial hubris, and imposes a $2 billion penalty on American taxpayers. Let's think about that. Imposes a penalty on American taxpayers. No, Sam Alito, this is an appropriation of the Congress. Only if you believe that every time the Congress passes a budget, passes a tax bill, appropriates monies, that's some way penalty on the American public. No, it's monies that are properly there as a part of the budget. We anticipate, we expect, we call upon our elected representatives in Congress to do exactly that. You may not agree with it. That's why we've got a legislature that sometimes says yes. They vote on things. It's not a penalty, Sam Alito, and nothing is being imposed through judicial hubris. An extraordinary dissent, 8-page dissent. And again, a decision by the majority, 5-4, including Amy Coney Barrett, including the Chief Justice, including the three others, plainly Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson, in the majority in this case, sending this back to Judge Ali and saying, go ahead and do what you need to do. Enforce what you want to do. We'll take a look at it down the road. That's a major event in American history that happened just this past week. Again, it's got everything. It's got intellectual dishonesty. It's got some notion about a constitutional crisis looming. You note that Judge Ali had said, gee, they're probably not going to follow what I'm directing them to do. It's got Supreme Court procedure, it's got foreign policy, and it's got the emergence of Amy Coney Barrett once again. Lots of things to unpack from that decision. A very major decision coming out of our United States Supreme Court, and more of those plainly down the road. That happened just this past week. Something else happened this past week in a very different area of jurisprudence, and we have seen that before. We've talked about this before, and that is the Supreme Court's area of exposure and work when it comes to the Environmental Protection Agency, environmental laws, including the Clean Water Act. We've talked about this a lot. Remember that Sackett case from a previous term in which the Supreme Court basically eviscerated the Clean Water Act in some language that prohibited the EPA from enforcing its designated responsibilities, again, given it by the Congress. Sackett was a major blow. We've got another one just this past week, also as a result of decisions by the Supreme Court. This also 5-4. We have different alliances, different groups that make up that 5-4 decision. Undeniably a setback for the EPA, and could probably have some major sweeping implications for curtailing water pollution offshore in America. It's a blow, this time to the EPA. Supreme Court siding with San Francisco just this past week in a challenge to water quality regulations issued by the Environmental Protection Agency. Again, 5-4 decision, a blow to the agency undeniably, basically saying you can't do what you're doing, or at least can't do it the way that you're doing it. The case also, as we've noted in the past, we've described this as a part of the docket back in the fall, some very unusual alliances here. You've got San Francisco, the city of San Francisco, on the same side as some groups you wouldn't normally think that they would be on the same side with. That's the mining and petroleum trade groups, things like the National Mining Association, the American Farm Bureau Federation, the American Fuel and Petrochemical Manufacturers, all of them together, including the city of San Francisco, opposing the EPA. Now, how does this come about? How do we get here in the first place? Well, the dispute fundamentally focuses on it arise from how human waste and how San Francisco disposes of that human waste in that city. The question before the court was whether the Clean Water Act of 1972, it's been around for a long time, allows the agency, the Environmental Protection Agency, to impose prohibitions, restrictions, limitations on wastewater released into the Pacific Ocean, and then to penalize the city for violating those regulations. Once again, we hear from Sam Alito. This time, he's the majority, so he's much happier this time around. He writes from the majority that the EPA was entitled to impose specific requirements to prevent pollution, but not to make polluters responsible whenever, as he said, water quality generally falls below the agency's standards. It's an interesting way of understanding the work of the EPA. He goes on to say this: when a permit contains such requirements, this is Sam Alito writing now, a permittee, someone who gets the permit, that punctiliously follows every specific requirement in its permit may nevertheless face crushing penalties if the quality of the water in its receiving waters falls below the applicable standards. That's pretty much an articulation of the law. Whether or not it is crushing, there are penalties that go along when you fail to abide by what the EPA has done to keep our waters, including, yes, the Pacific Ocean, clean for future generations. The Chief Justice in this case, John Roberts, Clarence Thomas, Brett Kavanaugh, joined that majority opinion. Neil Gorsuch joining most of it, not all of it. And here, once again, here's the continuing theme on this broadcast and previous broadcasts of Amicus. Justice Amy Coney Barrett, once again, joining the court's three-member liberal wing. And you know who they are, once again: Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson. They make up the four. Interesting, once again, a gender split, as we have seen in other cases. 5-4, those four joined together in saying that no, the agency did everything right. At least they didn't do anything wrong here. She says, this is Amy Coney Barrett again writing in dissent of what her conservative colleagues, the other five, say. She says the agency was entitled to supplement, to add to some specific requirements for these water discharges with more general standards based on changes to water quality. She's giving the agency the authority we've talked a lot about on this broadcast, the discretion, the power to do what it knows it can and should do under the law. She said the need for the second kind of regulation, quoting from the government's very words in its lawsuit, is on display in this case. This is Amy Coney Barrett. Discharges from components of San Francisco's sewer system have allegedly led, this is Amy Coney Barrett writing this, led to serious breaches of the water quality standards, such as, here we go, discoloration, scum, and floating material, including toilet paper in Mission Creek. That's what Amy Coney Barrett wrote about the impact of what the Supreme Court majority has done. Justice Barrett added that polluters can now file targeted challenges to rules if they believe them to be unfair. If you think this is unfair somehow, you can identify a specific rule enacted by the EPA, but a statutory rewrite, that's an attack upon the conservative majority, was not warranted. That's what the majority is doing here. In the lead up, again, interesting backstory on all this, and lead up to all of this, San Francisco had said, we're really not attacking the EPA. They had pushed back on the notion that they were somewhat challenging the federal government's ability to regulate the environment. And I suppose you'd anticipate that from San Francisco, right? They said instead that they just wanted clarity. We're just not certain what we're supposed to do on this rule for the wastewater permit so that we can comply, that we can ensure that we're in compliance with the Clean Water Act. The lawyer for San Francisco had argued that city officials did not have some clear guidance on how to comply with the Clean Water Act, and therefore had been exposed to the crushing, that's his word as well, along with Alito's word, criminal and civil penalties, even when it otherwise complies with its 300-page permit. A little bit of a shot there, but nonetheless, that's how the case plays out. Coming out of the United States Supreme Court just this past week, more from the Supreme Court coming up as Amicus Law Review continues. My name is Jim Santelle, and this is once again Amicus, a law review coming to you this weekend from Madison and the broadcast station here, not too far from the University of Wisconsin, just in the shadow of our Capitol Dome. Max, my terrific producer, coming to you from Racine together, taking your phone calls, questions, as always, at 855-752-4842, spending virtually all of our broadcast time this weekend talking about the highest court in the land, the United States Supreme Court, some behaviors that may be somewhat concerning when it comes to the president engaging the Chief Justice right after the State of the Union, the reaction by Amy Coney Barrett to that interaction, and then these major decisions coming out of the Supreme Court just this past week, both of them 5-4 decisions, noting the split between the justices, but different kinds of alliances, making up that 5-4, rejecting Donald Trump's attempt to freeze foreign aid, sending that back to a lower court, and then issuing the EPA a ruling that basically clips its wings when it comes to its possibility of enforcing the Clean Water Act out there in San Francisco. Also a 5-4 decision, noting once again the emergence of Amy Coney Barrett in that case. She has also, as we have noted in the past, put some distance between herself and others. She has very notably taken on Clarence Thomas when he has been all focused upon looking back to history and looking back to ancient history to decide things like First Amendment decisions, certainly when it comes to the guns rulings. She's more and more saying, you know what, that's craziness. We should be looking at what the law means today, a contemporary application in 2025 in the early part of the 21st century. The lessons that some of the lessons that may come out of the past are important. We should know those, but they should not be telling us what we should do. Amy Coney Barrett distancing herself on that notion of reliance upon history and tradition as these cases go forward, and also finding herself in the minority when it comes more and more to these environmental cases as well. This is not the first time that she has sided with the three others on the Supreme Court and saying that, yes, indeed, the agency, the EPA, the President of the United States, a case under Joe Biden, should be able to do some of this, should be able to regulate our air as well. And more we see Amy Coney Barrett making her own path, and we see that a lot this past week. Another case, not decided this past week, a couple of weeks ago. However, an important case because for a few reasons. Once again, this is a unanimous decision. This is where Amy Coney Barrett and all the other justices agree unanimously on what should happen here. It is plainly a decision premised upon the law, but nonetheless a decision that probably it will strike you as it strikes me as the kind of thing that calls out for justice beyond what the Supreme Court has done. Supreme Court, about 2 weeks ago, rejecting the petition, the request of some Holocaust survivors against the nation of Hungary, unanimously ruling that the plaintiffs in this case had not established a connection to the United States that was required under the law, under the Foreign Sovereign Immunities Act. Again, the Supreme Court unanimously ruling that a group of Jewish survivors of the Holocaust would not win. They said that they could not sue Hungary in the United States to recover what? To recovering the proceeds of property stolen by its state-owned railway. The company apparently robbed hundreds of thousands of Jews before sending them to Nazi death camps in 1944. One of the, if not the most horrific event in human history in recent times. The question for the justices was whether the suit was barred, again, by this legislation passed by the Congress. It's called the Foreign Sovereign Immunities Act, a 1976 law that, for the most part, prohibits suits against foreign states. The law has some exceptions, including one for the expropriation of property. But that exception, that part of the law, also requires proof that the stolen property, which is the focus of the lawsuit, was exchanged for, that's the language in the legislation, exchanged for property in the United States in connection with some commercial activity. Now, once again, this comes in the wake of true horror. More than 500,000 Hungarian Jews were murdered. We know that well, in a matter of months near the end of World War II. That genocidal campaign that, yes, indeed, it happened. It's a part of the horrific history of humanity. It was accompanied by a mass theft of Jewish property, spearheaded at the time by Hungary's National Railway after a government declaration there that all valuable objects owned by Jews, except for a few personal items kind of around the edges, were part of the nation's wealth, seizing all that property. Horrific, right? The survivors, including their families and others, had argued that the stolen property had been liquidated, commingled with other money, and used decades later in many transactions with the United States, and that's why they invoked this legislation, including the issuance of bonds and the purchases of military equipment. However, that explanation, that connection was too attenuated. And we have Associate Justice Sonia Sotomayor writing for the court, a majority court saying, sorry, this particular piece of legislation does not permit you to go ahead. She said this: Hungary has made countless transactions throughout several institutional collapses and regime changes, resulting in billions in revenues flowing in and out of its treasury. Goes on to say, and against this historical backdrop, it is implausible to say that the commingling Hungary did in the 1940s on its own establishes that the money it spent in the United States in the 2000s was, here's the language once again, exchanged for the property Hungary allegedly expropriated. Again, a lot of things to unpack there, basically saying haven't met their burden of showing this connection with exchanges of property that are more recent. It was one thing, Justice Sonia Sotomayor basically said, to trace a stolen piece of, for example, art, traded for another piece of art, but very different, she said, to sell the art and deposit the cash from that sale in a bank account, for example, that's used for commercial transactions. She goes on to say that mere fact does not relieve plaintiffs from alleging some facts that enable the reasonable tracing, that's the key, of those proceeds to the United States, establishing jurisdiction here. Justice Sotomayor, again, probably, as all the justices we hope would be, look at this with dismay. She says, we acknowledge there's a moral imperative to provide justice for the Holocaust victims while they still live. She said, unfortunately, the plaintiff's broad reading of the 1976 law would undermine the United States' foreign relations and reciprocal self-interest. Again, we know that the United States, also a party to many lawsuits overseas, about 1,800 actions against it pending in the courts of more than 100 countries at any given time. So these issues about foreign litigation, foreign pieces of litigation going on, they loom large on the face of the planet. This past week, the Supreme Court saying this particular piece of litigation here cannot proceed. More about the United States Supreme Court coming up in the second hour of Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I am your host for this, the second hour of our weekend broadcast, devoted entirely this weekend to the United States Supreme Court. Well, maybe a couple of footnotes coming out from other federal courts as our discussion of jurisprudence and the law and the rule of law continues here on Amicus, a law review. As always, encouraging your comments, questions for Max and me, my producer, Max, there in Racine. I am coming to you from Madison, Wisconsin. The phone number through which you can be a part of our discussion is 855-752-4842. Talking again all about the Supreme Court, a number of major decisions it has rendered just in recent days, one of them having to do with the incapacity of some Holocaust survivors to seek remedies against the Hungarian government in American courts. Another one clipping the wings of the EPA when it comes to wastewater and the Clean Water Act. And this third, not final decision, but nonetheless major constitutional decision deciding that Donald Trump should not get his way. And indeed that a lower court that is stopping him from freezing these overseas foreign aid packages. Judge continue to do that. He has to provide a little bit more detail for the parties, but refusing to enter into the kind of agreement with Donald Trump that Donald Trump would like. All of that happening by the United States Supreme Court, in the United States Supreme Court, just in recent days. Also, an awful lot of oral arguments going on, including just this past week, 4 oral arguments altogether. We've got a couple of them on Monday and Tuesday having to do with, again, the interpretations of law. We're not going to spend a lot of time on these, but they're interesting cases. They join the 64 cases that are already pending before the United States Supreme Court. Some of them, a few of those resolved, as we just indicated. Most of them awaiting decision. And so just this past week, in anticipation of those decisions, the United States Supreme Court taking up an interpretation of something called the Foreign Sovereign Immunities Act, FSIA. Supreme Court also taking up something called the Justice Against Sponsors of Terrorism Act. All kinds of important things when it comes to understanding and interpreting what laws passed by the United States Congress that people now need to have interpretation on. That's what the courts do in America. And we also know that just this past week, on Tuesday and then on Wednesday, the Supreme Court entertained oral argument on 2 equally important, but now we're going to focus on these in particular, one having to do with guns and, again, foreign policy, international engagements, and a second one having to do with the Nuclear Regulatory Commission and its capacity to act in America when it comes to nuclear waste. What can it do? What can it not do? Again, important to emphasize that these are oral arguments. These are opportunities for the parties, principally through their attorneys, to come before the Supreme Court and argue their cases, to have these discussions, often very animated, between the justices and the parties who are representing the positions there before the Supreme Court. When you're in Washington, D.C., you can actually go to the Supreme Court, and these are public proceedings. You can be there, take in the oral arguments themselves, be a part of that process. You can also hear all about the oral arguments on the radio here on Civic Media, because we often broadcast portions of those. You can also go online and pull up the complete oral arguments. They're posted by the United States Supreme Court. Chief Justice said, yes, I'd like for everybody to be able to hear what we're saying, some level of accountability and indeed transparency when it comes to what the Supreme Court is doing. So that's what's going on this past week. Oral arguments, not decisions yet, although once again, we can usually often read some tea leaves. Read some tea leaves kind of indicate how the Supreme Court will probably be resolving a case. So, for example, we knew in December, long before the Supreme Court issued its major decision in Dobbs overturning Roe versus Wade, we knew back in December, early December of the previous year, the Supreme Court would almost certainly be going in that direction. It wasn't a surprise when they did that in June. Sometimes the tea leaves are clear, sometimes they're not. We've kind of got a mixed bag in a couple of cases of just this past Tuesday and Wednesday. Let's talk first about guns and the Supreme Court and the nation of Mexico. Again, much in the news recently in connection with our relationship with it. Tariffs on, tariffs off. Supreme Court appearing skeptical, very, very doubtful, at least most of the members, this past Tuesday, that the Mexican government now suing in our courts, suing gun makers over claims that they, the gun makers, the manufacturers, the distributors, share some blame for the violence in Mexico by drug cartels. Now, how does that get unpacked? Here we go. Mexico would argue that the American gun industry bears responsibility for the violence in Mexico. How? They allege that the gun industry in America creates and sells firearms that then make their way across the border into the hands of criminal gangs in Mexico. And Mexico, now through its representatives appearing in our United States Supreme Court, which they can do, that's a part of the process that is open to litigants in America. They argue that the violence in their nation, in Mexico, was a direct result of the gun makers' actions, and that the country should in fact be able to sue those manufacturers despite, notwithstanding, a 2005 law, again passed by Congress, that provided that most lawsuits against gun manufacturers cannot go forward, basically prohibiting these kinds of gun manufacturer attacking lawsuits for injuries caused by those firearms. Justice Kavanaugh, for example, during the course of this oral argument, appeared pretty much to sum up the doubts that some of the justices had about the lawsuit by asking about the broader implications if Mexico was successful here in arguing that manufacturers acting lawfully could be held responsible for illegal behavior by cartels in a foreign country. The Justice Kavanaugh said an outcome that worried him because it could have destructive effects on the American economy. That's what he said in the course of this oral argument. Went on to say lots of sellers and manufacturers of ordinary products know that they're going to be misused by some subset of people. This is Kavanaugh talking now. He cites car makers and pharmaceutical companies. The lawsuit then is argued further. The case, again, filed in 2021, has allowed the Mexican government an avenue for a counter-argument. And that is that the U.S. gun makers share in this blame, this is their advocacy here, for violence by these drug cartels because their guns make their ways, as we indicated, as it's set forth in their complaint, to the Mexican crime scenes. Mexico is asking for some $10 billion in damages for the movement of those guns across the border from America into Mexico. A trial court judge, based upon the start of this lawsuit, had dismissed Mexico's case against 6 defendants on some other grounds. And so the only parties in front of the Supreme Court were Smith & Wesson, a gun manufacturer, plainly, and Interstate Arms, was a wholesaler of these guns. Access to guns, according to the representatives in the Supreme Court, tightly controlled in Mexico. They said it's nearly impossible for civilians to legally obtain the kinds of military-style weapons favored by the cartels. Now you see where this is going. They're maintaining that they can only get those basically from the United States of America, crossing the border, ending up with the drug cartels. Lawyers from Mexico, citing to the Supreme Court statistics showing the majority of the guns from Mexican crime scenes, 70 to 90%, they said, come from the United States. And so they contend, this is their argument, that gun dealers in the states where we live here, that border Mexico, and that otherwise are the places where these guns are produced, sell twice as many weapons as dealers in other parts of the United States. In other words, those places along the border are twice as likely to have those guns end up in Mexico. There's a lawyer for the gun industry. His name is Noel Francisco. He used to be the Solicitor General under the Trump administration. He's arguing in favor of what the gun industry is saying, pushing back on this claim against them. He's arguing the industry was specifically insulated. The Congress came forward, passed a thing called the Protection of Lawful Commerce in Arms Act. That was way back in 2005, basically saying after a growing number of lawsuits were being brought to hold the gun industry responsible for these mass shootings that, again, continue to populate our history, our communities and terrorize us on a regular basis. Lawsuits being brought against the manufacturers and producers and distributors of guns. The legislation ultimately prohibits many types of those lawsuits against those manufacturers and sellers. So Francisco, again, representing the gun dealers and manufacturers here, says the law is clear. Can't go ahead, cannot do this. He said the Congress's entire purpose was to prohibit lawsuits just like this. He went on to say it was trying to prohibit lawsuits that had been brought by the city of Chicago, the city of Cincinnati, the city of Boston, on theories and seeking relief exactly like this one. However, and this is how Mexico gets into court, the law also carves out an exception for claims to protect the certain aspects of this. Claims can proceed if the plaintiffs can show that their injuries were somehow directly caused by knowing violations of firearms laws. And Mexico has argued that its case falls under that statutory, that legislative exception. During the argument, the lawyer who argued for Mexico said that these manufacturers have designed specific weapons to appeal to Mexican buyers. She talked about a special edition .38 pistol. It's engraved with the face of Mexican revolutionary hero Emiliano Zapata, with a quotation that has been attributed to him historically. He apparently said, "It is better to die standing than to live on your knees." That language appears now upon a .38 pistol engraved on the face of it. She said Mexico is not trying to legislate gun use in the United States. However, she gets some pushback, including from Ketanji Brown Jackson, who questions Mexico's argument here. The Chief Justice, the Associate Justice, says that she read the 2005 law as about Congress protecting its own prerogative. This is Ketanji Brown Jackson, to be the one to regulate this industry. Again, the lawyer for the gun manufacturers, for Mexico rather, saying, no, we're not trying to do that. We're simply trying to get some compensation for what's going on here. What happens is that there are, after all, according to Francisco once again, millions of perfectly law-abiding Spanish-speaking Americans in this country that find those firearms very, very attractive, and making those firearms available cannot possibly cross the line into aiding and abetting. That's Neil Francisco. When we come back, we'll tell you more about that oral argument and another as Amicus, a law review, continues. This is Amicus, a law review. My name is Jim Santelle, the host of this broadcast. In these remaining moments and minutes of our second hour here, talking all about the United States Supreme Court. I appreciate very much not only those of you who have called in the past, but also lots of people on our text lines. We're going to get to those as well, making certain that you know that your voice is being heard on this broadcast. In the connection with this oral argument pending before the United States Supreme Court this past week, Mexico trying to attempt to hold gun makers responsible for the violence in its country, prompting some skepticism about the legitimacy of this lawsuit going forward. Among other things, we have Justice Samuel Alito. We're hearing a lot from him in this broadcast, referring to the strained relationship between the two countries in recent days in his questions to a lawyer who's representing Mexico. Justice Alito saying he wanted to raise a question that may be on the minds of ordinary Americans, some of whom believe that Mexico is contributing to illegal conduct in the United States. Sam Alito went on to say if Mexico wants access to U.S. courts to argue the country was being hurt by U.S. companies, this is Alito questioning, would it also agree to suits in which the U.S. states argued Mexico should be held responsible for increased law enforcement costs and welfare benefits? Kind of a back and forth. Justice Alito asking the question this way: would your client be willing to litigate that case in the courts of the United States? And of course, lots of back and forth on that. The attorney said that kind of suit would violate Mexico's sovereign immunity, prompting Justice Alito to say that it appeared that Mexico is arguing for a one-way street if it wanted to sue gun makers when it could not also agree to be held responsible for harm, as Justice Alito described it, caused in the United States. A fair amount of skepticism about the possibility that this lawsuit can proceed. And it appears there may even be some, across the political aisle, if you will, a skepticism about that based upon the strength of this legislation that generally prohibits this kind of litigation, even with this exception. Again, we'll anticipate getting the decision of the United States Supreme Court on this case. On this case is Smith & Wesson Brands versus Estados Unidos Mexicanos, sometime probably in May, maybe June of this year. Supreme Court also taking up a fourth case this past week. This one involves the Nuclear Regulatory Commission, and yes, that's right, nuclear waste. The issue is stated legally this way: whether the Atomic Energy Act and the Nuclear Waste Policy Act permit the Nuclear Regulatory Commission to license private entities to temporarily store spent nuclear fuel away from the actual reactor sites where the spent fuel was generated. Now, how does this come about? Well, the United States has grappled, as you probably know, with nuclear waste storage since the 1940s, trying to figure out what to do here. Initially, it was from weapons development, and later from commercial nuclear power. Spent nuclear fuel was originally intended to be reprocessed, and that proved very impractical. Again, all this coming out of this litigation pending in front of the Supreme Court led Congress to pass the Nuclear Waste Policy Act in 1982. That particular piece of legislation, again, a piece of legislation coming out of our Congress, designated a place in Nevada as the nation's permanent underground repository and required the Department of Energy to begin accepting waste from states in 1998. But amid some strong opposition and some delays in implementing that, constructing that place in Nevada, the Obama administration halted work on that mountain location and established a commission that recommended a consent-based approach to siting storage facilities. Following that shift in policy, then, waste control specialists applied to build a nuclear waste storage facility in Texas. They said, we'll take advantage of that change in the policy of the government. And despite opposition from the Texas governor, as we can well imagine, and the legislature itself, and frankly, they passed state legislation prohibiting the storage in their state, the Nuclear Regulatory Commission, again, a federal agency, issued a license in September of 2021. The Court of Appeals for the Fifth Circuit, we know that well, vacated that license, holding that the legislation under which the Nuclear Regulatory Commission was acting authorized the commission to do lots of things, but not this particular thing. And so we get this oral argument. A federal judge, again, reversed the decision at the lower court level, and basically along the way brings this case then to the Supreme Court. Supreme Court once again seemingly divided over whether Texas and companies that own land in the Permian Basin there in Texas have the right to challenge a federal plan to let as much as 40,000 tons of this highly radioactive waste be temporarily stored at a privately owned off-site facility. That's how practical this issue comes up. The court's so-called liberal wing on Wednesday seemed to agree that the state and property owners didn't have the ability to sue over what the NRC had done, this permitting, because they weren't an aggrieved party. And so you get, for example, Justice Elena Kagan saying, when I look at this, your only participation in the agency proceeding was to be excluded from it. She said, but then you're saying, well, if I was excluded wrongly, I'm a party. I mean, she said, how could that be? Arguments, again, follow, as I indicated, an awful lot of historical wrangling about this involving nuclear waste and nuclear issues generally. A ruling rejecting the challenge would likely turn on the question, this is what the Supreme Court has in front of us, whether parties denied an opportunity to intervene in the National Regulatory Commission's initial licensing decision, whether they should be allowed to challenge that license now. It has a lot to do with the chronology and the way in which these things go forward. Elena Kagan again said those parties might have a good argument as to why they shouldn't have been allowed to be a party, but it's not to say that you were a party. In fact, you were not. And so you're out of luck by virtue of the timing of this. The conservative wing of the court just this past week seemed to say that they thought the NRC, in denying intervention to parties in the first place, should not get to decide who gets to challenge the decision now. Clarence Thomas speaks up. He says, I do think it's somewhat strange that the NRC gets to choose which parties are able to challenge it later on. And Sam Alito seemed to be concerned once again about the storage site being temporary. Again, we're talking about the nuclear waste there. He asked if it would be considered a permanent site if decades went on and the permit was then renewed. He also wanted to know what incentive there is to do what Congress wanted, which was to establish a permanent facility. Again, as I hinted at earlier on, a federal appeals court had previously ruled against the NRC. This above-ground site in Texas would be the first of its kind, be designed to take waste from commercial reactors around the country until this long-running fight about this permanent storage location in Nevada can be resolved. The opponents, of course, say that the federal law expressly requires the nation's nuclear waste to be stored in Nevada, where efforts to build that facility have been halted recently. Despite billions of dollars spent on that site, it is currently just a hole in the ground. That's how Justice Neil Gorsuch described it in this oral argument of this past week. The case is once again called Nuclear Regulatory Commission versus Texas and Interim Storage Partners versus Texas, pending before the United States Supreme Court, getting some mixed reaction, again, from the Supreme Court justices themselves based upon that oral argument. We will see what they do again, May, June, maybe July of this year. More about the United States Supreme Court and other courts when Amicus Law Review continues. This is Amicus, a law review. My name is Jim Santelle. Thank you for continuing to engage with Max, my producer, and me in some of these major issues having to do with the Supreme Court. Decisions it's making, decisions it's anticipating making. We appreciate especially those of you who are participating by dropping your comments into the Dropbox. I am going to immodestly read some of those we've got from Brown saying, thanks for the great show, Jim. I'm starting to think Judge Amy, speaking about Amy Coney Barrett, might really be taking her job seriously, Brown says. He also notes as a footnote, he says, also love your tie, very punk rock. That was exactly the look I was going for, Brown. Appreciate the comment very much. Also, Chris from Eau Claire noting, thank you for the amazing information you provide. Look forward to your show every Saturday and your guest appearances throughout the week on Civic Media. Indeed, by way of a bit of a promotion here, I'll indicate to you that in addition to this Saturday and Sunday morning production coming out of Civic Media, Amicus, a law review, also fairly regular appearances on Jane Mantenaer's show and Maggie Dawn's show and Dom Salvia's show, Pat Kreitlow, Up North News, and John and Gordy as well. Delighted to be a part of all of that, mostly because the news does not wait, and the importance of having that news into the ways in which you can understand and appreciate it, important throughout the week. Thank you so much for those very, very nice comments. Also, getting some comments from others that raise some terrific legal issues and rule of law issues. This is Cornell asking, is there any way that Trump can be prosecuted for treason under Article 3, Section 3 for aiding Russia? And again, they're the kind of thing that an awful lot of people are looking at these days. Gerald Ford, as I've often repeated, very notably said in the past that you can impeach based upon whatever you think is an impeachable offense. The Congress talks about high crimes and misdemeanors, but we've seen many, many expansive understandings of what that language means in the Constitution. There certainly is a growing body of support for the notion that when it comes to the president following the law, taking care, that's the take care clause of the Constitution, he is not doing what he is supposed to do under the Constitution, according to the oath that he took in office. Specifically when it comes to these situations where federal judges, more and more, including Judge Ali and others around the country, are saying you're not following what I'm saying, that does lead to a constitutional crisis if a branch of government simply refuses to comply with the others, simply refuses to comply with the basic understandings that establish our system of checks and balances. And so the question, Cornell, more than just rhetorical, needs to be asked. Is this a president who has run afoul of his oath of office in doing these things that are in violation of statutory law, of the Constitution? There are plainly grounds for drafting those articles of impeachment. Whether or not under this particular political situation those articles would pass, highly unlikely. Certainly when it goes to the Senate for a trial, highly unlikely a trial would result in a conviction removal. But the question is the important one, Cornell. Thank you for being a part of our broadcast. And similarly, there's another note here about if there was a similar support for the right to vote as there is for the right to bear arms, we would probably have a far more fair and just society in this country. That's Len from Madison. Could not agree more with you, Len. Important to note that, and significant that we think about these things in comparisons, right? That we think about the ways in which one particular set of legal principles does in fact affect another. We should try for consistency and to ensure that we've got an understanding, not of perfect consistency when it comes to applications of law, but some sense of regularity. The Constitution is something you can rely upon. The language means something. The language of statutes means something. Appreciate all those comments and more here on Amicus, a law review. Before we depart the Supreme Court, one more action that they also took just this past week, also warranting attention here on our broadcast. You know as well that the Supreme Court up to now has accepted for review about 64 different cases, including some of those we've talked about in this broadcast. Supreme Court continues to add a bit to that docket by granting what are called writs of certiorari. That's the writ, that's the order that they grant, basically saying that we'll take that case. If a writ is denied, that means we're not going to take that case. We're not going to review it as well. The Supreme Court has recently said that it's going to enter once again the area of religion in America. First Amendment, Establishment Clause, Free Exercise Clause, said that it will decide whether Oklahoma, the state of Oklahoma, can create the nation's first religious charter school. Plainly a case that could continue a streak of rulings that we have seen recently, in which the Supreme Court has sided in favor of establishment of religion, frankly, by the government, contrary to what our First Amendment says. 2022, many of you may recall, the court said that Maine could not exclude religious schools from an indirect aid program based upon the school's religious use of funds. A couple of years before that, the court said that a Montana scholarship program could not exclude religious schools if the program was open to any private schools. And indeed, in 2017, even before that, the court backed a church's challenge to its exclusion from a Missouri grant program to resurface playgrounds. All of those approving and supporting the use of public tax dollars to support particular institutions, particular educational entities that have a religious nature about them. And the argument, of course, in the opposite direction is that's contrary to the Establishment Clause that again, draws this line between government and religion in America. Well, the case that the Supreme Court has just taken on is also notable because the Oklahoma Republican governor and the attorney general there are opposing these positions on funding this school. And that is no small thing to note. Again, the Supreme Court taking on this case. The Archdiocese of Oklahoma City and the Diocese of Tulsa said that they should be able to operate a K through 12 charter school, even though the curriculum would include religious instruction, plainly getting money, but nonetheless including religious instruction. An Oklahoma court, the Supreme Court, last year said that the charter schools, which again use these monies, these public monies, but have private operators, are public schools, and state law requires public education to be non-religious, secular. They got it right, the Oklahoma Supreme Court. The Oklahoma Attorney General, his name is Gentner Drummond, said Oklahoma's charter schools bear all the hallmarks of a public school identified by this court and more. And he actually urged the Supreme Court not to get involved. Do not grant the writ of certiorari in this case. Stay away from it. The Attorney General there said allowing this Catholic charter school would open the floodgates and force taxpayers to fund all manner of religious indoctrination, including even, he said, the Church of Satan. So this is the Attorney General of the state of Oklahoma encouraging the Supreme Court not to take this case. Nothing here to see. The Establishment Clause prohibits this from happening, should not be sending federal public funds into a charter school that has religion as a part of its commission. Now, plainly, the proposed school, it's the St. Isidore of Seville Catholic Virtual School, was narrowly approved in 2023 by a state governing board in that state. And attorneys, again, seeking some action by the Supreme Court, told the justices that they should step in. Why? And here's the important aspect of all this, because, as they said, religious parents are being penalized for seeking to exercise their religion. Now, why is that language so incredibly important? Well, that's really the new standard that has been articulated by the Supreme Court in that Maine case, the Montana case, the case coming out of Missouri. The Chief Justice, for example, being a leader in this area, saying that we no longer look to simply whether or not there is an inappropriate intrusion of government into religion or vice versa. We no longer look to where the line is drawn, but instead we determine whether or not there is an inappropriate penalization, a penalty, some sort of discrimination, as the Chief Justice has said, against religious entities, including religious schools. And if there is discrimination, you cannot prohibit them from using public funds that may come into their coffers under regular circumstances. Again, this appeal, filed by the Catholic Church, had the backing of multiple conservative, some religious groups, and 8 conservative states also saying, yes, indeed, take this case. And plainly, it's opening the door to a very significant change in the way that we would understand the Establishment Clause, arguably the Free Exercise Clause, but mostly the Establishment Clause in our First Amendment, seeking clarification from the Supreme Court now about how charter schools can operate. Publicly funded schools, charter schools, supposed to be non-religious, supposed to be secular in nature, if they in fact take those public funds but continue to provide religious instruction, is that permissible? Is that permissible under the First Amendment to the Constitution? The Supreme Court saying just recently that it will take that case on and tell us sometime again in May or June of this year what the law in this area should be. A very interesting matter coming up on the docket now. Among those 64 cases the Supreme Court is deciding. Supreme Court plainly, unmistakably doing a lot to affect, to change, to provide not just context, but meaning to our lives and livelihoods here in the United States of America. That extends as well, of course, to federal district court judges and also to federal appeals court judges. We know when we talked about Sam Alito early in this program that he's got it just wrong when he says that federal district court judges cannot act unilaterally. Well, they do act unilaterally because they're one person. Now, those decisions by independent and presumably nonpartisan judges, that's the way we should interpret them, can be appealed, and they routinely are appealed to appeals courts. There in our federal system, you get a 3-judge panel typically that will review the decision of a lower court. And sometimes you'll get in what's called an en banc review. That is, all the members of the appellate court may review a lower court decision issued by a singular judge. That can happen. That does happen with some frequency in America. And then ultimately, once again, as we have talked about at great length here, if you're still unsatisfied with what the appeals court does, whether it's in a 3-judge panel or an en banc review, you can seek review by the United States Supreme Court. That's the due process of our American system. That's how we got 64 cases pending before the Supreme Court. Many, many others plainly not getting that review. One of them now recently going to get that review is this religious case coming out of Oklahoma, in which the quality, the nature, the focus of the First Amendment Establishment Clause will once again be tested. We do have federal district court judges, singular judges, acting just this past week, also to affirm this fundamental notion that was implicit, if not explicit, in what the Supreme Court did earlier this week, basically saying, Mr. President, you can't do these things. Mr. President, your actions when it comes to following the law are not consistent with doing just that. You are obliged, Mr. President, to take care, as the Constitution says, that the laws of our nation be faithfully executed, and you have not done that. Let's talk about a couple of cases in which federal district court judges, one in the District of Columbia, one in the District of Rhode Island, have sent that message to Donald Trump just this past week, all a part of our continuing monitoring the fact that federal judges remain the guardrails in this nation, at least up to now, even through this process of pushing back on these unconstitutional and statutorily unsupported actions by our president. Federal judges being the ones who say, no, you can't do that. Of course, highly dependent upon an administration that understands that when a federal judge says something, you have to follow it. And that's the rub. And that's when you do, in fact, get the constitutional crisis that we made reference to before. We do have these 2 judges, however, who are articulate and clear, some wonderful language reaffirming what the dissenters in that Trump versus United States case said way back in July of last year, saying that we do not have kings, that the president is not above the other branches of the government. In fact, the laws apply to everyone equally, including the chief executive. What happens in one of these cases? Well, a federal judge just this past week reversed the firing by the Trump administration of a National Labor Relations Board member by President Trump. and saying along the way that American presidents are not kings. When we come back, we'll tell you more about that NLRB case coming out of Washington, D.C., another one coming out of Rhode Island to the same end as Amicus, a law review, continues. My name is Jim Santelle. This is Amicus, our final moments of this 2-hour broadcast. Again, appreciating so much all of you who have decided to be a part of our discussion. Thank you for that. Mark from Prairie du Sac writing, I'd still challenge the court to actually define official acts. He's talking obviously about our previous discussion related to impeachment and other processes in our government. He said that or amend the Constitution to remove impeachment and the take care clause. Hamilton pointed out in Federalist 69, regardless of the cherry picking SCOTUS did to make that their decision, the president still subject to some punishment and great disgrace out there. Katie from Madison also noting, thanks for a great show, Jim. I've always learned so much. Katie, that's the reason for our show. Amicus, a friend to the community, a friend to you. Appreciate so much and value your comments, your contributions to our discussion here on Civic Media. Talking about this decision issued just this past week in which a federal district court judge says that the president is not a king. The order reinstating former National Labor Relations Board member Gwen Wilcox came a month after Ms. Wilcox sued to return to the board after Donald Trump had fired her. Here's what the federal district court judge says in response to that in issuing this order saying, no, Mr. President, you can't fire this person. The judge, her name is Beryl Howell. We've heard from her before in connection with many of the January 6th defendants. Judge Beryl Howell writes this past week, the president does not have the authority to terminate members of the National Labor Relations Board at will, and his attempt to fire plaintiff from her position was a blatant violation of the law. Can't get language clearer than that. Hours after the ruling, after Beryl Howell said just that, of course, Donald Trump has filed, as he can do, a notice of appeal to the U.S. Court of Appeals in the District of Columbia. That can go forward. The decision by Judge Howell, however, is worth reading. And it is significant, once again, that she affirms what we all know, that the Trump's interpretation of the scope of his constitutional power, or more aptly, she says his aspiration for that. She says what Donald Trump wants to do, his interpretation of the Constitution, here were her words, flat wrong. She said an American president is not a king, not even an elected one, and his power to remove federal officers and honest civil servants like plaintiff is not absolute, but may be constrained in appropriate circumstances as are present here. That's the federal district court judge talking. A president who touts an image of himself as a king or a dictator, perhaps as his vision of effective leadership, fundamentally misapprehends the role under Article 2 of the Constitution. That's the word coming from Judge Beryl Howell in reversing the firing of the chair of the NLRB just this past week. Strong but appropriate words to be sent to the White House. Interesting to see whether or not the courts of appeals, ultimately maybe the Supreme Court, when they take this on, what will they do in the wake of the great affirmation of the power, the authority of this executive branch that it put in place back in July. We've got another judge. His name is Judge John McConnell. He's in the Federal District Court in Rhode Island. He extended an order that prevented Donald Trump's administration, here's the word once again, from freezing billions of congressionally approved domestic funds to 22 states and the District of Columbia. These are monies intended to enhance our national life and livelihood in our nation. The judge found that the administration had overstepped and again, not taking care that the laws of our nation be properly executed in trying to stop agencies from using monies properly, legally, lawfully appropriated by the Congress. Again, the ruling, which builds on the judge's prior temporary order. We've talked about this before, the initial comments and the initial orders entered by Judge McConnell, instructing the government to keep dispersing those funds. Judge McConnell previously and again saying, no, the legislature has decided, there are representatives, they've passed laws, previous presidents have signed those laws, so there's nothing unconstitutional about the way in which they've been put in place. And all of this, again, setting up this clash between the president and federal district judges, maybe appeals court judges as well, maybe even the Supreme Court at some point, but certainly a clash between what the Congress has done and what the president is not doing, inconsistent with what the Congress, its purpose and its intention had been. Judge John McConnell, again, Rhode Island, says this: here the executive has put itself above Congress. It, meaning the administration, the Donald Trump administration, imposed a categorical mandate on the spending of congressionally appropriated and obligated funds without regard to Congress's authority to control spending. A memo from the White House Budget Office had demanded a pause on billions in grants until the administration, you may recall this news, could determine that the funding complied with the priorities, the newly announced priorities of this administration. We know the confusion, the alarm, the disarray that this order, among others, had set off. You've got attorneys general around the country who sued to prevent this from going ahead. In their challenge, they pointed to specific examples about how critical funding from these agencies that Donald Trump was stopping, like the Federal Emergency Management Agency, yes, that's right, that's FEMA, or the Environmental Protection Agency we talked about earlier in the context of this case coming out of the Supreme Court, could leave the states stranded in emergencies, unable to provide vital services, things like clean water. Judge McConnell said that the directive from the Budget Office, again, these are his words, fundamentally undermines the distinct constitutional roles of each branch of our government, and that without this action, the funding that the states are due and owed creates an indefinite limbo. The order on this past week was aimed at all federal agencies cited in the memo from the Budget Office. It directs them now to refrain from pausing, freezing, blocking, canceling, suspending, terminating, or otherwise impeding the disbursement of appropriated federal funds to the states under awarded grants, executed contracts, or other executed financial obligations. That's a judge, that's a lawyer saying, let me give you all the possible permutations of this. There is no way that you can get out from under my clear direction to restore this funding. Don't try to get around this by indicating that I've not covered something in my very omnibus language. And indeed, Judge McConnell noted, like other judges, that the government still appeared to be defying his earlier temporary order. Now, these judges have decided not to hold the government, not to hold the administration in contempt yet, but this is exactly when, if indeed this continues, then we really will have a constitutional crisis. We often talk about that. We bandy that word about with great liberality, and we'll note that, for example, Watergate was not a constitutional crisis. Why? Because the president there, in the end, abided by it. As we close out, we ask whether or not this president, many years later, will abide by the rule of law, taking care that the laws of our government be faithfully executed. All of this, a continuing question here on Amicus, a Law Review. Thank you for joining me this weekend. Come back again next weekend for more here on Amicus, a Law Review. Have a good weekend, everybody.